welcome to ECR Tools. Once again, we bring to you the ICCPR following on from the Universal Declaration of Human Rights, 1948, December 16. Then basically that was just a declaration. It's not, it's a non-binding, some sort of agreement within the member nations. And so this is where the ICCPR, which is the International Covenant on Civil and Political Rights, and also the ICESCR, which is the International Covenant on Economic, Social and Cultural Rights, come into play in 1966, ratified in 1976, 23rd of March, and this then becomes a binding international treaty for member states, currently standing at 173 member nations. We talked about Professor M.B. Dambo's various schools of thought about human rights being either naturally given, and also the deliberative school of thought, which says write that down, get nations to sign it. When they violate it, take them to court and enforce, international court, and enforce the judgment of the breach. And then you have the protest school of thought that says protest if an individual's right is being abused. This is like the case of George Floyd and the Black Lives Matters movement. Then you have the school of thought, the discourse school of thought that says just talk about it, have a chat, talk about it, bring it to the attention of people, and human rights will work. In my own opinion, the four works together, but I'm more interested in the active side of things, which is the deliberative school, which says write it down, just like we read in the ICCPR, so that if a nation breaches it, then the individual knows what their rights are as stated in the article, and they can engage a lawyer, an international lawyer, to actually go to an international court to ensure that their rights are not being abused. Remember to like this video, share, add your comments and contributions. The idea is an educational platform. Let's hear what you have to say, but secondly, share it, because the more people know about their rights, the better it will be that such rights are not abused. And this is why we bring the ICCPR to you. Also to make you aware that national laws are mostly written that actually borrows a lot from the international treaties, because the states are bound basically by law, by international law, to uphold such international treaties. And therefore, if these international treaties come into conflict with international law, domestic law comes into conflict with international law that has been signed and ratified by nations, then therefore those nations, the international law supersedes the domestic law. This is why you have seen that challenge between the British Parliament and Strasbourg, which is the European Court of Human Rights. Right, so we move on to Article ICCPR, Article 12. So Article 12 says that everyone lawfully, Article 12.1 says everyone lawfully within the territories of a state shall within that state territory have the right to liberty of movement and freedom to choose his residence. Article 12.2 says everyone shall be free to leave any country, including his own. And so Article 12.3 says the above mentioned rights shall not be subject to any restrictions except those which are provided by law or necessary to protect national security, public order, public health or morals, or the rights and freedom of others, and are consistent rights recognized in the present covenant. And so it tells you that as an individual living in a state, you have that freedom of movement to choose your own place of abode, and also have the right to leave the country if you wish, if you so wish, and you should never be restricted under any circumstances except for when there is an issue of national security, also public order. So if you have a person whose presence or absence may cause a problem of national security or public order, then surely that person can be restricted for that matter. Public health, morals, or the rights and freedom of others. So if your actions obviously affect the rights of others, then that as well, you may come under some sort of a restriction. I remember back in the sort of late 90s when, characters like Louis Farrakhan was blocked entry into the UK for maybe his so-called radical views. Okay. No one shall be arbitrarily deprived of the right to enter his own country. So therefore, a person have the right to be in their own country and should be able to go somewhere and return to their country. However, we will see the case of that young lady. I'm trying to remember her name. This British citizen that went to one of these countries. Maybe she was like a terrorist person, obviously joined a terrorist group and was not allowed to come back. Once again, in the next video, I will research. I just remember it on top of my head, but this was a case whereby one could have argued that his nationality she was even deprived of her nationality, because once again she would have fell under the sort of national security and public order issue. And so yes, these are sometimes when things become a little bit technical. So Article 13 of ICCPR says, an alien lawfully in the territory of a state party to the present covenant may be expelled therefrom only in pursuance of a decision reached in accordance with law, and shall, except where compelling reasons of national security otherwise required, be allowed to submit the reasons against his expulsion and to have his case reviewed by and be represented for the purpose before the competent authority or a person or persons especially designated by the competent authority. So this is to do with possibly, immigration issues. So whereby, the person may pose a problem for national security, then such persons may not then have that right where they can basically have their case being held in a court of law, and also have that opportunity to remain in that country. That is, if they are deemed to be a risk to the nation. So we've had instances, I think, there were some instances with some prisoners in Belmarsh prison that may have come under this ICCPR Article 13. So move on to Article 14, ICCPR. Article 14.1 says, all persons shall be equal before the court and tribunal in the determination of any criminal charge against them. or of his rights and obligations in a suit at law. Everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. So this is interesting. This is equality before the law, and also equal access, and obviously to a judiciary, an impartial judiciary system. There are problems currently with judiciary independence or judicial impartiality. Problem has been mainly a lot of clubs, gentlemen clubs, whereby you may have, say, parties of business interest, parties with business interest may be in club with judges, and therefore if an individual should have a problem with such a party, or sort of a business party who is in a club with a judge, then how do you then guarantee impartiality within the judiciary system? So there are problems currently, and this is one could say is a global problem. Judicial independence, yeah. The press and the public may be excluded from all or part of a trial of moral public order or national security in a democratic society, or when the interests of the private lives of the parties so require, or to the extent strictly necessary in the opinion of the court, in special circumstances where publicity will prejudice the interest of justice. But any judgment rendered in a criminal case or in a suit of law shall be made public except where the interests of juvenile persons otherwise required, or the proceedings concern matrimonial disputes or the guardianship of children. So once again, Article 14.1 of the ICCPR, we see that play in the domestic environment, where, people's rights, juvenile children's rights are being protected from some sort of publicity in the courtroom. And so it does says that if a person poses national security, or if a case poses national security or public order issues, then such cases may not necessarily be held in an open court where people can actually see these proceedings go on. Article 14.2 says, everyone charged with a criminal offense shall have the right to be presumed innocent until proven guilty according to law. And so this is also a very important article where you are presumed innocent until proven guilty. The film by Michael B. Jordan, Justice, is a case, I think it's a true story based on a person that was placed on death row, and basically the evidence held against them, basically did not hold. And it was deemed that such persons were practically presumed guilty until proven innocent. This was the case in America. So this lawyer made an effort in fighting for the rights of such people that were on death row, and some of them were released for the fact that there wasn't sufficient evidence against them, and also of the fact that in the manner that they were treated, they were probably presumed guilty until proven innocent. So once again, this article basically states very clearly, it's Article 14.2 of the ICCPR. So you are innocent until proven guilty. Article 14.3. In the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantee in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. And so these charges must be explained to the person in a language that they understand. B. To have adequate time and facility for the preparation of his defense and to communicate with the counsel of his own choosing. And so this is where obviously the person must be granted counsel and also in a timely manner that they could prepare their own case. We know that obviously over the years, this service where individuals are able to engage lawyers, I think as a pro bono sort of thing, seems to be dwindling over the years. To be tried without delay or undue delay. D. To be tried in his presence and to defend himself in person through legal assistance of his own choosing. To be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. And so once again, Article 14 3D that state that if the person does not have funds to defend themselves, then the provision should be made to them by the state so that they are able to prepare a defense. 14.3e says to examine or have examined the witnesses against him and to obtain their attendance and examination of witnesses on his behalf under same condition as witness against him. So these are witnesses. The person should basically have the right to see these witnesses, cross-examine them through their own counsel of the of any forms of accusation against them, where witnesses are provided. Article 14.3f. To have the free assistance of an interpreter if he cannot understand or speak the language used in court. So this is where interpreters come in. And 3G, Article 14.3g says not to be compelled to testify against himself or to confess guilt. So this, we also see this. Sometimes you have instances where even you engage a counsel and they try to ask you to basically admit guilt when you yourself, you have engaged them to actually defend you because you know that you are not guilty. Then they actually sometimes maybe advising you to admit guilt, and this is all a prohibition under Article 14.3g. So Article 14.4, in the case of juvenile persons, the procedure shall be such as will take account of their age and desirability of promoting their rehabilitation. Article 14.5 says everyone convicted of a crime shall have the right to his conviction and sentence being reviewed by a higher tribunal according to law. So this is when you are tried on a case and if you're not happy and satisfied, then you can actually basically take the case to a higher court so that you can get the justice that you so think you deserve. Article 14.6 says when a person has by a final decision been convicted of a criminal offense and when subsequently his conviction has been reversed or has been pardoned on the grounds that a new or newly discovered fact shows conclusively that there has been a miscarriage of justice, the person who has suffered punishment as a result of such conviction shall be compensated according to law unless it is proven that the non-disclosure of the unknown fact in time is wholly or partially attributable to him. And so this aspect 14, Article 14.6 does talk about, obviously, where there is miscarriage of justice, that such persons shall be due compensation. If such convictions have been reversed based on new evidence. So Article 14.7 says Article 14.7 says no one shall be liable to be tried or punished again for an offense for which he has already been finally convicted or acquitted, or in accordance with the law and penal procedure of each country. So this is to do with double jeopardy under the US Bill of Rights. So this is what I was saying before, that these laws are coming in from the past and they are being readopted into the laws of now and the future. So Article 15 of the ICCPR says Article 15.1 says, no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed, nor shall a heavier penalty be imposed than the one that was applicable at the time when the criminal offense was committed, if subsequent to the commission of the offense, provision is made by law for the imposition of the lighter penalty, the offender shall benefit thereby. It seems this is to do with, obviously, when an offense or a crime is committed and, persons are brought to a trial and they're convicted, then the lower, based on what the crime was, the lowest form of punitive judgment will apply. Article 15.2 says, nothing in this article shall prejudice the trial and punishment of any person for any act or omission which, at the time when it was committed, was criminal accordance to the general principle of law recognized by the community of that nation. Article 16 says everyone shall have the right to recognition everywhere as a person before the law. So the right of the person. Article 17.1 says no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attack on his honor and reputation. So very important. ICCPR Article 17 is the right to privacy. So in modern times we have seen where, the application of the use of cameras, cameras everywhere. If you are in an office or any place where cameras are being used, then those there should be clear notification of the fact that camera is being used in that area, and the purpose of the usage of the camera must be explained, and also must be ensured that such information are not used contrary to what they are indeed expressly deemed to do. So that is also an issue there. And so you have that right of privacy for yourself, for your family, for your home, and for your correspondence, that nobody should interfere or intercept your 17:2 says everyone has the right to the protection of law against such interference or attack. So there you go. Article 18 of ICCPR says, Article 18.1 says, everyone shall have the right to freedom of thought, conscience, and religion. The right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others in public or private to manifest his religion or belief in worship, observance, practice, and teachings. So that's the freedom of religion and freedom of thought. Once again, you will notice that under the U.S. Bill of Rights, all these the freedom of religion and freedom of consciousness is enshrined in the U.S. Bill of Rights. And so you can see that it comes further down into the UDHR and then finally getting into the ICCPR, and it even extends further to ECHR, and obviously also the African Commission on Human and People's Rights. So Article 18.2 says, no one shall be subject to coercion which will impair his freedom to have or to adopt a religion or belief of his choice. And so you cannot be coerced as an individual from your choice of religion. So Article 18.3 says, freedom to manifest one's religion or belief may be subject only to such limitations as prescribed by law and are necessary to protect public safety, order, health, or moral, or the fundamental rights and freedom of others. So we see the story of Waco in 1994, if I remember sort of vaguely, when the U.S., I think maybe the FBI, basically invaded David Koresh, I think his name was, who was trying to brainwash some people on religious grounds and to try to basically have them kill themselves. And so at this stage, then this person had actually pushed his freedom of religion to another level, where he is now violating the rights and the security of others, and therefore the FBI then it was basically a shootout, and a lot of people lost their lives, but the majority of them were saved. And so brainwashing cult, these sort of religious cults, are the ones that are deemed to be dangerous, and therefore the such may not be covered under Article 18.3. So Article 18.4 says the state parties to the present covenant undertake to have respect for the liberty of parents, when applicable, legal guidance to ensure the religious and moral education of their children in conformity with their own conviction. Therefore, the parent has the right for the education and the religious education of their own children according to what they choose seems right. And so therefore, parents may have their children removed from certain lessons if they deem that is contrary to their own maybe educational and religious beliefs and convictions. So thank you once again for watching ECR Tools. Like our videos, share, add your comments and contributions. It's an education platform. Come and say what you think, and obviously spread the word so that people know their rights, especially the younger generation, that they know what their rights are so that their rights are not abused. So thank you for watching. Have a good night.